Good evening. Good evening. Sorry, there's a little bit of a sound backlash. But I hope we can all be heard clearly. For those who are just joining us, thank you for joining us. Tonight we have the honor and the privilege of hosting a citizen of this country who steps into one of the most demanding and consequential roles in the constitutional infrastructure of Uganda. He sets foot into one of the most thankless jobs in the justice infrastructure of Uganda. Tonight, colleagues, we are hosting none other than the Director of Public Prosecutions, a position that carries enormous responsibility and great expectations. And it is held, he's holding this office historically. Mr. Anguzu, I think, is the first, since the coming into force of the 1995 Constitution, he is the first career prosecutor to raise to the office of the Director of Public Prosecution. His eminent predecessors, I think almost without exception, were sourced from the judiciary. One being a former chief registrar, others being former judges, and currently are actually serving as judges. And so his appointment is a vote of confidence in him and in his And today we are here in his maiden public interview, so to speak, with the members of the bar. Lino, the Judicial Service Conversations is the fireside chat of the bar. It is the parliament of the bar. We meet here every Wednesday. We began meeting here because we were trying to solicit the support of colleagues in another bid, which certainly may not concern a public official, and we don't intend to incite you into partisan bar politics. But nonetheless, we began here these conversations to bring a torch into the practice of law, and they have grown and developed a life of their own. It is now the parliament of the bar, where we sit down, where we listen, and where every Wednesday we come together and learn. And so we want to understand today how you see your office, what you believe prosecution should stand for, and how you intend to build a system that is fair and accountable to the citizens of this country. We want to hear your thoughts on the changing nature of crime. We want to hear your thoughts on all the matters touching prosecution in this country. But above all, people are interested in knowing the philosophy, the mind, the heart, the flesh and the blood of the Director of Public Prosecution. I must, of course, inform the public that the job is one of the most thankless jobs anywhere on earth in the criminal justice system. Few people, it is a job of great stress because you have a lot of people from all sides pulling and pushing, and I think that as a person who has been doing this job all his life, Lino has learned how to be happy in sad circumstances, because sometimes you see the most gruesome crimes. Sometimes you participate in decisions that are really tough from the public side, and Lino has been at the heart of this, and I think it is a great election of him, that a great decision to have made him a prosecutor. I must confess and declare an interest that I know Mr. Lino very well, and I am extremely happy and proud that he is the Director of Public Prosecutions. So, having declared that interest, allow me to welcome you all once again. And Lino, once again, welcome to the Judicial Service Conversations. And we'll shoot straight into it. The first question we always ask people who join these conversations is this: who are you? Who is Lino Anguzu, and what makes you tick? Tell us about the man. Forget about Uzaz. Also, you've done a delay on us. You've delayed our whatever. Yes.
I first need to know that you can hear me.
We can hear you loud and clear.
Am I audible?
Yes. Yes, we can hear you.
Okay. All right. So good evening, Elison and everyone. Thank you so much for the
we can hear you.
very elaborate introduction. I am truly humbled, and so said so many things about me, and I also have to declare. I think before we start, I need to declare conflicts of interest. I know Ellison, and so when he asked me to join in on this discussion, I could not say no. So I think having got that out of the way, so who is Lino, and what makes me tick? Of course, you all know by now, my name is Lino Angozu, and I'm the Director of Public Prosecutions. I come from Arua, West Nile, born and bred. I think I only left Arua when I was coming to the university. I am a prosecutor, of course, lawyer, but by career, I'm really a career prosecutor. From LDC, I think I only did 1 or 2 temporary jobs, and straight dug into prosecution as a state attorney. And we're talking 2004, so I've been around for about 21 years. And so almost my whole entire life has been in the service of the office of the DPP in various places and responsibilities and assignments, of course. And so what makes me tick? One is I really love my job. I love breaking new barriers. I love solving puzzles. I love paying attention to detail. I really very difficult challenges, difficult cases, especially legal ones. I enjoy teamwork, working with my people, but I like to excel in what I do. The funny thing about this is really, I think my cornerstone, what really lies at the corner of all this is justice. I think everyone deserves to be heard fairly
in whatever they do. This is really what makes me tick. And when I wake up every day, go to work, go to office, I like to really help other people, do something for them that they cannot do for them. It gives me satisfaction, and it makes me really fulfilled. And at the bottom of this, I'm a very private person, very simple and a private person. I like to keep everything simple. I hate bragados and bossing people around. I like to just, blend in quietly without anyone or everyone knowing who I am, what I do. And so usually I just like to blend in quietly. And so I don't like a lot of attention, public attention and stuff like this. It's not for me. And so that, I think in brief, really, that is what I will say who Lino is and what makes me tick, Elison.
Thank you, Lino. We congratulate you on having lost your anonymity, having lost your privacy, having lost all those things as the Director of Public Prosecution. And welcome to the field. It is such a fantastic thing to host the DPP, especially when it's Lino, who likes his privacy, and host him on such a public platform. As some people may know, these days I'm also a defense lawyer in some small criminal matters. And so it is very good to have the chief prosecutor here himself. And I can see many of my colleagues from the office of the DPP on. I think maybe Lino, I think many people would want to know, now that you're the DPP, what do you think about the role of the DPP, your new role? And as a DPP, people would want to know what guiding principles come to your mind. So basically, the question is, what do you see as this new role? You have a constitutional responsibility, a responsibility designed in the Constitution. What do you see as your role and as the role of that office? What do you see as as your role and as the
All right. Thank you, Elison, and thank you, of course, for robbing me of my privacy. I think it was about time. I'm not very growing any younger after all. And so, so what is what do I think is the role? That is the role of the office of the DPP guiding principle. I'm sure. I don't know how many people are logged in, and I don't know how many of them are lawyers and how many are not lawyers. But my assumption is that majority of the people on this platform right now are lawyers. I'm sure we must all be familiar with the Article 120 of the Constitution, which is really the legal foundation of the office of the DPP, that constitutional office. But what is really the role of and what is the guiding principle? And so what do I look forward to be driving me? I think the Constitution provides some general guidelines. I think it's at 125. It guides the director on what principles should guide the director in the performance of his duties. The director must have regards to the public interest, the interest of the administration of justice, and the need to prevent abuse of legal process. So you can essentially fit everything in terms of key guiding principles there. Public interest, what? Interest of the administration of justice, too, and they need to prevent abuse of the legal process. So those are three. And then you can feel a lot of these things: professionalism, accountability, independence, fairness, impartiality. All of those you can fill them into those broad guidelines. But for me, really, the DPP is like the first judge in criminal cases before the judge. The DPP is the one who provides the first preliminary judgment on any case, criminal case, to determine or guide and say, okay, I think this one, this person did not do ABCD and so should jump out. Or this one, I think he has one or two questions to answer, and so I think let me place this person before a tribunal, a competent tribunal, so that I get my belief as the DPP that I believe this person committed a criminal offense, tested by another independent institution, the judiciary. And of course, that's not a very easy task to do, because there are not many cases which are in black and white. There are a lot of gray areas, and so a lot of what we are taught in law school, principles like this, really you find it tested. But you have to make a judgment call and a decision. And if you keep these guiding principles, that the first thing is that you must look out for the public interest in every decision you make, everything you do. The second, you must look out for the interests of justice. You're dealing with two people here. There is a victim of crime. There is an accused person, And then on the other hand, you need to prevent abuse of legal process, but also you have the public as a third party in this, the interest of the general public in a particular case, in a particular type of conduct, and all that. And so for me, really this is what I think the guiding principles lie there: independence, firmness, with courtesy. You can still be firm and independent and be courteous. You don't have to scream at people. You don't have to, but your role is to make your decision. And the moment you make a decision and you're able to explain it, account for it, and be confident in it, I think that is really what
We are
drives
hosting
me.
the learned DPP of the Republic of Uganda, and we're inside his mind. And I think we've had the guiding principles: fairness, firmness, independence, courtesy while you are making the decision, but the firmness. You know, I think the former American President George Bush wrote a book called Decision Points. That he said that his job was about making decisions. Now he just had the very busy office of a president. I think the prosecutor is a daily decision maker, and he makes decisions concerning the lives, liberty of citizens of this country. For many Ugandans, Lino, this is their first time hearing from you. And I think before we delve into the more meaty parts of the conversation, people will want to know how you describe your own personal approach to justice. I think you've given us the constitutional architecture, but people would also want to know about your own approach to justice as a decision maker who has to make decisions firmly, independently. You are not, you're not holding the office of Pilate, where people have to buy a basin and wash their hands and say, there's some noise outside, let me make a decision. Yours has to be a decision based on evidence, on facts. So people would want to know your approach, your personal approach to justice.
Hmm. Again, Lisa, so my personal approach to justice, I am not sure if it has to be my personal, but I think it probably is what I believe is the right approach to justice and what I will probably follow. My personal approach is that justice is an objective, a commodity. And again, I picked this from my mentor, my predecessor, Justice Emeritus, DCJ Emeritus Richard Butera. That justice is an objective commodity. There are very many justice actors in the justice chain. Take a particular criminal case, you have very many people who are looking for justice. The community is looking for justice. The court or the judiciary or the judicial officer is looking for justice. The victim is looking for justice. The accused person is looking for justice. Everyone is looking for this thing called justice. And so, Mr. Butera told me, you see, sometimes when you lose a case, that actually is justice, regardless of your subjective opinion or feeling about the decision taken by a judicial officer or the approach taken by a prosecutor or by a defense counsel. But it says the outcome, the objective outcome of a process, that is really justice. And so the important thing is to lay down the rules and the principles and apply them and follow them. So if the procedure says, and which is the law, if the law says that everyone who is accused or alleged to have committed a criminal offense must be investigated, can be legally detained and robbed of some of his rights, and must be brought before a court of law, and they must be tried, and the Initial evidence must be investigated by police, of course, and that evidence must be assessed by the DPP or a prosecutor, who will make a decision that the matter must go to court. And the matter goes to court, and it is subjected to this scrutiny through a very rigorous trial process, and the judgment is delivered. So when that process is followed, the law is clearly laid down under which you are. For me, that is really the concept of justice. But my approach is, as a prosecutor, from the prosecutor's point of view, my approach is to treat every case the way it is, and look at every case in the eyes of looking at a victim, a physical victim of the crime, and putting yourself in the place of that victim, and looking at the accused person, the person who is alleged to have committed the crime, and putting yourself in the foot or shoes of the person who is alleged to have committed the crime, and then putting yourself in the shoes of the state and the government, which represents the public. What are the interests of the public in this matter? What is the interest of, how is the impact of in this matter? And so when you look at every case like that, and you look at this victim, you see what they've lost, the pain they have gone through, the scars they're going to live with. And then you look at the accused person, the possibility that he may actually be innocent and this allegation may be wrong. The fact that he's likely to lose his liberty for a very long time. His family is going to suffer, that there are consequences there. He may not provide for his family, the likelihood. And the moment you look at all these, and then you will know and understand the responsibility which is placed on you to make sure that you do the right thing, and that the decision you make must be the right decision. And then when you're sure that you have made the right decision, you stand firm by it, because you have the law behind you, because the law authorizes you, the law permits you to take the steps that you have taken. And then you can go home without feeling guilty, whether the matter goes one way or another. And I think your role in this process is really to do your best within ethical guidelines, professional standards that guide your profession. Do your best. If you're a prosecutor, you believe your case is true, you believe your evidence is cogent, present all that evidence and prosecute the case to the best of your ability. If you have knowledge and understanding that the evidence is not there, take the steps to bring that out, to make sure that the case doesn't stay there beyond it is. Two, if you're defending an accused person, your job as defense counsel is to defend your client to the best of your ability, and do all in your power to show the world, or to demonstrate that this person is not guilty of this offense, or is convicted of, or is being tried of. And if you're a judicial officer, your role is to be fair. Listen to all sides, give them opportunity to present their cases fairly, to cross-examine, to test the veracity of evidence, and make a fair decision. And if all these processes work properly the way they were designed to work, the product you receive is what I believe is really justice. And that, for me, really is my approach to justice. So as a prosecutor, I'll be insisting that we do our best to analyze our cases properly, to scrutinize the evidence critically, and once we are convinced that the evidence is good and that it is tested, it is believable, it is credible, that case must go to court, and it must be prosecuted vigorously to its logical conclusion. If there's a change of circumstance and the case cannot proceed, then the case must get out of the way. And if right from the start the case is a non-starter, you can really see that there are good grounds why the case should not be there, and then the case should never go to court. And I believe
I agree with you that if the case is a non-starter, it should never go to court. I can think of a few, but we shall not discuss particular cases. But I think that's a fair summary of really the roles, first of all of us at the bar. And I am very refreshed that the DPP sees, and I'm sure the office has traditionally seen, and maybe sometimes we that there is a collegiality, at least that has come, that says there is a role for the cross-examiner of the evidence. There's a role for the prosecutor. There's a role for the judicial officer. And that all those roles must be done with integrity. You know, even the Bible says that this is a verse somewhere between Genesis and Revelation. It says that when the first person to speak sounds true until someone comes forward and cross-examines him. I think that is Proverbs. I'm advised that is Proverbs, which is between Genesis and Revelation. There's a book called Proverbs. If you open Proverbs from the first chapter to the 31st chapter, somewhere in there, you will find this verse. And I know the DPP is a very strong reader of the Bible, but before we go into scripture, I think one other thing, I think we've seen all these roles, and today we're in a very interesting era. When in Uganda in particular, we're at an interesting point in history. And before maybe we delve into some of these other questions, I think one question that I'm seeing is, in your view, what should in your view, what should a modern prosecutor do differently? We are living now in different times, and there is the challenge on the prosecutor's office. And what should a modern prosecutor do differently?
Ellison,
Yes.
First of all, I am just trying to contextualize what you mean by a modern prosecutor, but I think you mean a prosecutor today, the contemporary prosecutor.
Yes.
Who is in the office of the IGG, is in URA, is in office of the DPP, and has the amiable role of conducting public prosecutions on behalf of the public. My view is the modern prosecutor needs to have a complete change of mindset. The mindset needs to completely change from that of purely a prosecutor to that of an officer of justice and a public servant. And when you have that mindset change, that you, as a prosecutor, that you are an office of justice, and whatever you do is not just on behalf of your employer, it's not just on behalf of URA, but it is on behalf of the public, and that you must be accountable. That is going to change a lot of things, because what does that mean now? That means you must stop looking at just convictions alone. And you will stop looking at every case as a conviction. You will look at every case like a believable case, that this is a case you believe yourself as a prosecutor in your professional judgment, but then you will understand that your professional judgment is not the final position, and that your professional judgment is still subject to further refinement and testing through the judicial process. And therefore your role is really to do what is fair, what you believe is just, and what you believe is professional. And so a modern prosecutor, in order to do this, you must train yourself. You must be competent. You must be competent. You must be able to understand the law. You must be able to properly apply the law to the facts. You must be able to properly draft your documents. You must be able to properly articulate your cases. You must be able to properly advocate for your cases. So you must be competent as a prosecutor, as a modern prosecutor. But not only that, we live in the age of AI now, and so you're not going to remain in the Stone Age. You must continuously educate yourself, improve yourself. So you must do an equivalent of collect your equivalent of CLE points with the Uganda Law Society, and so you must get to know what are the new crime trends, what are the challenges, how to deal with new kinds of evidence and new kinds of crimes and all these things, technology and all of that. So this is the approach that a modern prosecutor must adopt, but you must be ready for the challenge. Practice is growing. Ugandans are becoming more aware of their rights. They are litigating a little more, and they're defending themselves more vigorously. More Ugandans are now educated, and so they understand the law a little more. More people understand the law, and so you're not going to do the usual things that we used to do. And so, if I can summarize what I'm saying, I think what I'm saying is that the modern prosecutor must improve the quality of prosecution. The quality of the prosecution service, whether it is decision making, whether it is drafting opinions, whether it is whatever it is, whether it is advocacy in court, you must improve the quality of prosecution that you
welcome to the Judicial Service Conversations. We are inside the mind of the DPP,
the modern world
the future of law and justice, and I'm seeing that a number of you are sending forward very many questions. We will, in about 15 to 20 minutes, come to the questions that you're sending out. But I just want to salute. I see questions from Mr. Philip Karugaba, a senior advocate. I see questions from Mr. Lule Alexander, the Central Region representative of the Uganda Law Society. I see a number of questions from a number of colleagues. I'm seeing someone is asking us about the verse. Proverbs chapter, I am advised, fortunately, the pastors have sent me messages. Read Proverbs chapter 18, verse 17. We are having the DPP with us today, and we are going to go through all the questions that we have in the limited time that we have the DPP with us. So bear with us. If you have questions, please continue to send them through. We will be picking them at a particular point. Either myself, Joy, or Alfred will be reading them. Lino, we have with us here a number of interesting lawyers. One of them is called Mr. Alfred Muyaka. We also have Mr. Timothy Amerit, and we shall be coming to Timothy, who you know and who is a guest of the DPPs today. As you know, the tradition and culture of the Judicial Service Conversations, which has started only recently, is that once a senior advocate comes, he must come with a colleague. And we shall be giving the colleague some moment to say something. But we also have Mr. Alfred Muyaka. Now, Lino, Alfred is the Secretary General, Deputy Secretary General of the East African Law Society in charge of young lawyers. Now, I don't know if he's the youngest lawyer in the Law Society, but he has some young things that he's doing. And so I think I'll hand over to Alfred at this point.
Yes, thank you, Mr. And thank you, Mr. Limo, for joining us in this conversation. I want to congratulate you on the appointment, especially from the young lawyers whom you present. Just as you are sharing from your 20 years experience, then you shared your personal view of justice, the role of the DPP. What in my mind is the thing that justice is never delivered by one institution alone, it's a collective effort. So from your angle as the current DPP, how would you see the office of DPP working more effectively with the police, with the bar, with the judiciary, to strengthen the justice system and deliver better outcomes for Ugandans? Because just even on the call, we have people from the police, we have people from the bar and from the judiciary, and since justice is a more collective effort, my question is regarding how we can have Office of DPP working more effectively with everyone to deliver justice. Thank you.
Thank you, Alfred. I don't understand our society these days. I don't know why we like to disaggregate, or is it segregate our society into, now we used to know it's lawyers, now we have young lawyers. I don't know. Alfred, you will probably educate me this young lawyer, maybe I'm a young lawyer, I'm almost 50. Maybe I still qualify to be a young lawyer. But anyway, that is just besides the point. But it's a pleasure, Alfred, listening and hearing from you. And it's also thank you for joining us this evening. Okay, so how do I think the point is to understand why these different institutions exist. If you can ask that question and answer it, and then you'll understand the significance of all the criminal justice, not just criminal justice, but justice institutions working together. Okay, so if we have the court, why do we need the office of the DPP? If you have the office of the DPP, why don't we just use it since they make decisions? Why do you have the police, Uganda police? You have the Uganda police. Why do you have the Uganda Law Society? You have the Uganda Law Society. Why do you have the Uganda Prison Service? Now, if you can ask those questions and seek the answers to them, therein you will find the significance and the importance of each of these institutions and the distinct but important roles they play in the justice chain. And therefore, the moment you recognize that, I think you will only draw one conclusion, that it is inevitable and absolutely critical that all these criminal justice institutions should work together. And so the question, I think, if I understood it, is how do you work together? How you intend to work together with all these other criminal justice? As I said, justice is not for me. It is an objective commodity where everybody contributes something small. But because of the unique nature of this idea that we call, or concept we call, justice, I think our forefathers, or the people who crafted for us our justice system, must have determined that it is significant, and for good reason, probably, that we have different institutions playing different roles, but all ultimately contributing to achieving this product called justice. And so, how do I intend to foster this coordination, cooperation? First of all, it is inevitable. It is not like I have any choice, or that the DPP has any choice in this matter. The mere fact that you have to work with them means you have to coordinate with or operate with them. You can do this at senior level, at very, very top executive level. You can do this at senior management level, but also you can do it really at the grassroots level, DCCs and so on. But this involves speaking to each other, sharing your problems and your challenges mostly, and also providing feedback to each other on areas where you're doing well and areas where you're not exactly doing well, supporting each other, and also pointing out areas where we need to increase partnerships, and areas where we think we are doing very well that we need to strengthen. And so it's all about participating in each other's activities, and so that you understand your unique challenges as institutions, but also you understand the roles each institution plays, and you get to appreciate it. Sometimes we don't agree, which is, and there's some friction every once in a while, which is very normal because of the different mandates of the different institutions in the justice chain. But my approach really to collaboration, partnerships with, is just to speak, first of all, at leadership level, meet with the leaders, agree on the big issues, strategic issues, operational issues, and then allow those to trickle down or cascade down in the hierarchy of the institution, so that then it can be reflected at lower levels. But also it also requires treating every institution with some decorum, with some courtesy, and with some understanding, with a recognition that the institution is an independent institution, that it is different, has a different mandate, which may be completely different from the mandate. For example, I will give you an example. If you take the Amnesty Commission and you take the office of the DPP, our role or mandate as the office of the DPP is to prosecute. The mandate of the Amnesty Commission is to grant amnesty to people who are deserving. And so you find the two mandates almost seem to be conflicting. And so when you're dealing with each other, you need to see how you can work together, because this is the same government. You're all working for the same state, the same government, Uganda. And so you're all working to achieve one thing, whether it is peace, whether it is the law and order in society. That is what every institution is working really ultimately to achieve. In the justice chain, we are all looking forward to achieve justice. And so it is very important to meet in areas where you recognize that there are likely to be conflicting mandates and directly conflicting mandates. It's very important to meet at leadership level and agree on how to resolve some of these things. Clashing mandates, office of the DPP, for example, IG, we have mandates to prosecute the same. So what happens if IG takes cognizance of the matter, DPP takes cognizance of the matter? Should we move and IG move? At leadership level, you can move and have a memorandum of understanding or an agreement to say, look, on this matter, let's agree on matters where we have competing mandates. If it is a matter like this, we will cede mandate to you, you will handle it. And if it is a matter like this, please cede the mandate to us, and we will handle it. If we discover both of us are handling the same matters, we will probably hand it over to the first one who took cognizance of the matter, or to say, if one of us has already taken cognizance in the matter, and then the other one will not take cognizance of it, and move it over to the other. Agreements like that at leadership level on how you can harmonize your operations and your actions, I believe will go a long way in fostering a partnership. And then, of course, in the planning process, in the budgeting process, planning together, budgeting together, understanding and appreciating each other's strengths and challenges, I think is also another good way to foster partnership and cooperate and do things together. I think those are my insights on how you can work closely with a lot of the other criminal justice actors, but also supporting each other. If you don't have transport, we can provide you transport if we're available. If the other one is also changed on resources, you can say, no, we will cover this for you, and so on. After all, the resource envelope comes from the same basket. It is the same. Pass that dishes out these different resources, and so these really, Alfred, are my insights on how we can foster more close partnership or work closely with other stakeholders in the criminal justice.
With everyone involved, but when you look at the public perception, as currently the public seems to have lost trust in the office of the DPP, and yet public trust is central to prosecution and justice entirely. So from where I see it, or even from the comment section, what comes out is what the public wants to understand, or what we want to share with us is what those steps which you're going to put in hand to ensure that the office of DPP is going to use to build, maintain, and sustain the trust among citizens, lawyers, and the broader justice community, which seems to have lost trust in the office of DPP. Yet, public trust is really central to prosecution. We just want to hear from you those steps which you are going to take to restore the trust of the public. Thank you.
Thank you very much. Alfred, you put it very strongly that the public has lost trust in the institutional office of the DPP. I wouldn't really.
Thank you very much, Alfred. You put it very strongly that the public has lost trust in the institution of office of the DPP. I wouldn't really, put it the way you have put it. Probably I would say the public does not trust the office of the DPP so much. But I can tell you that if you see the number of people who say report the matters, who come to the office of the DPP and ask the office of the DPP to assist them, the number of people who have come back and said thank you to a prosecutor here for helping us to prosecute this matter. Thank you for taking our matter to the number of accused people have said thank you so much for dropping the charge. Thank you so much, and so you recognize that statement is a little too strong. I am cognizant, and I appreciate that we have a lot of challenges with public trust as the office of the DPP. And some of the drivers of these challenges are really many: unethical behavior, unprofessional work attitude, and so many other things. And then this cloud of secrecy, confidentiality, under with which we do our work, because we deal with matters of criminal investigations, we deal matters of evidence. We are all public officers who, amongst our key oath, is the oath of secrecy, the undertaking not to declare or disclose information that comes to your possession by virtue of your employment. And so all these are challenges, but of course the biggest thing is unethical conduct. We have a lot of people, some of our staff are still engaged in a lot of unethical conduct, unprofessional conduct, not attending to duty in time, being late, absenteeism, mismanagement of cases, and of course taking bribes from members of the public, corruption. So all these things, and then being unaccountable, not explaining your decisions, not explaining why you certain things are in a particular way. So all these things contribute to the challenge we have. But I want to assure the public that we have taken all this into note. For the last 5 years, from the time Justice Abodo took place, I think this is one of the areas where she really focused to improve, first of all, the public's understanding of what we do as Office of the DPP, to give us more visibility, to make us more present in the public space, so that people know that there is something called the Office of the DPP. And so we have significantly improved our public appearance or public presence over the last few years, and I thank Justice Abodo for that. But also we have recently improved. We have recently launched our strategic plan, our 6th strategic plan as Office of the DPP, which will run us to 2030, and for the next 5 years. And in that strategic plan, we have changed our vision. We've maintained our vision, which is a crime-free society, but we have changed our mission. Now, our mission, we have actually focused it to address exactly this. And I told my staff that I am glad that I am going to get the driving seat in leading this transformation into this new mission, because our new mission emphasizes three key things: professionalism in the way we do our prosecution, responsiveness. We want our prosecutions to be more responsive to the needs and concerns of the public, and we want our prosecutions and our actions to be geared more towards the winning and the earning of public trust. And so public trust is key. It is now one of our mission statements. And so this is not something I would. So what are some of the strategies that we I am going to adopt to win, or I intend to adopt to win more public trust, more trust from the public. One, professionalism. We have to be professional. That means we have to improve the quality of everything we do. We have to improve efficiency in what we do. Two, we have to be more accountable. We must be able to explain our decisions to the parties that are relevant or are concerned, so that they understand that if we have decided not to take a matter to court, what the reason is, and we must be confident if we take the right decisions to explain to them that this is the reason why your matter cannot proceed beyond this step. This is the reason why you have to go to court and you have to be prosecuted. And so we have to be more accountable. Three, we have to continue maintaining our public presence. We have to be physically present. We have to engage with members of the public. We may have to disclose a little more than we ought to of what we're doing, especially to the parties to our cases. And we're talking about victims of crime. We're talking about complainants, people come complaining about on behalf of others. We're talking about accused persons and their lawyers and their relatives. And so we have to be a little more open to them, but also we also have to be a lot more engaging with the public through other public spaces like this one. And I think this is what I'm trying to do, to be a little bit and speak to everyone who is here, so that they understand the DPP is not just barricaded somewhere there in their office, but can come out. So we do barazas, we have a lot of public engagements, participate in court open days, so that you explain to public the things you do. Essentially, we want to be more accountable, but also we take feedback, so that the public tells us what it is we are doing right, what it is we are doing wrong. We have a very robust complaints mechanism that really, if well used, should go a long way in taking public feedback, and also making sure that we correct ourselves internally when there are errors here and there, timely and promptly. And so, for me, I want to really improve the quality of what we do. I want to improve efficiency within the office of the DTT, of the DPP. I want my prosecutors to be more responsive to the public, speak to them. In public relations, how do we speak to people? How do we treat our clients? Today, I was visiting our offices in Busoga. I am still here, but this is the message I'm delivering to all the prosecutors: that the public, our primary client. We don't have any other clients. The accused persons we have come from members of the public. Our witnesses are members of the public. The victims of crime, members of the public. So these are the people we work for. And therefore, it is very important for us to treat them with respect, regardless of who they are, whether they're an accused person or they're a victim or they're just following a matter. The way we speak to them, the way we attend to them, and the way we give them time is what is going to endear us to them. And so I am asking my prosecutors to be very responsive to the public, and I think that is one of the, and also avoid unethical behavior, taking wrong decisions, charging people who really shouldn't be there, and then refusing to charge cases where there is overwhelming evidence, asking for bribes in order to make decisions, and so on. And so I've been following these things. In the coming days, I'll be issuing a few statements, both internally, but also I'll be making a few statements publicly about some of these issues. But these are some of the strategies I have in my arsenal to win that public trust. In addition to this, we have published now. We have published our service delivery standards, which I think we are disseminating them now. So we have indicated what are the standards of service that we need to hold ourselves to. This is public information. We can provide it to anyone so that you know that if a file is going to the RSA's office for sanctioning, for how many days it's supposed to be there before a decision is made. So we have opened ourselves that, and in addition to that, we have published a client's charter specifically targeted for clients to explain to them what services we offer, what are the standards we offer, and how they can seek those services, from what points, where they can go if there are issues to raise, and so on. All this in addition to our internal mechanisms, complaints mechanism. I already talked about it, which is a very good feedback mechanism, but also strengthening internal supervision and quality assurance to make sure that there are successive levels of quality assurance and supervision for our staff, closer supervision of our staff, so that any bad attitudes or any wrong decisions are checked very early in the process before being perpetuated or estranged. And so all these are really strategies that I intend to employ to ensure, and I am very, very determined. And if there's one thing I really want to do, is to win back more of this public trust during my time here. And I am very confident.
Ladies and gentlemen, if you're joining us, we are inside the mind of the DPP, Mr. Lino Anguzu, and we are also at the Judicial Service Conversations. Lino, another guest we have here is none other than Ms. Joy Mbabazi. She's slightly younger than the youngest lawyer, Mr. Muyaka. And she's a forceful, not forceful, a peaceful, law-abiding. You know, when you're talking to the DPP, you must say there's nothing to charge, nothing to sanction. But over to you, Joy.
Thank you very much. Yes, thank you, Mr. Lino, for joining us today. We are really honored. And to everybody that is listening in right now, we appreciate you for choosing Judicial Service Conversations, where we have conversations that do matter. Mr. Lino, you have talked about very pertinent points in regards to what it is that you are intending to do, and I hear the highlights and the tone as well, that you're really, really looking and aiming at gaining back public trust, which is very good. And I also heard you mention some of the values or the things that you're pushing for, including professionalism, responsiveness, and then actions geared towards winning and earning the public trust. And then looking at efficiency, accountability, and the other thing was public presence. And you also mentioned about something to do with public service standards, something that you're yet to publish. I think you called it, is it the one that had the public clients charter, or is it different? Maybe for the benefit of the public, which is part of the listeners right here. And since we are having the honor of listening in first, if you don't mind, would you kindly share with us the highlights of this public service standards, some of them, and then maybe we can always look out for the detailed bit. Thank you, sir.
Thank you, Joy. These are called. We call them service delivery.
All right. Thank you.
Essentially, we have to sit down and give
These are called.
standards to measure what
We call them service delivery standards. Essentially, we had to sit down and give ourselves standards to measure ourselves and say, okay, so what are the standards we want to hold ourselves by, so that the public can judge us and say, these are the standards you gave yourselves, but look what you have done. And so some of them, unfortunately, I may not quote them direct, but I will try and remember. And they're published. They're already published. The documents are available. You can get them. I am going to find out from the PRO if they are already uploaded on the website. If they are not, that is where they are meant to be. And surely I will follow up and make sure you that. But I know there, I know there, I know there are hard copies which are already available and disseminated to various places. And so it's not true that they are not yet published. They're already published. And they're public. So they contain things like when a file comes for sanctioning, for how many days must it be in the office of the DPP before it is returned to police? And if it lays before that, if it lays beyond that number of days, what is your remedy? What can you do? And where is the point where you can seek that remedy, including the contact persons? If a file is, if a case is in court, it is being prosecuted. If it is a simple case, for how long should it be prosecuted in court? If it runs, what you can do. If it is a capital case, which has gone for further investigations, after how long should it be committed to the High Court before it becomes a matter of discipline? At what time should our officers be in office? For how many days should they work? From what time to what time? How essentially all of these matters are in the service delivery standards, which is different publication. But then we also have what is called the Client's Charter. And the Client's Charter is a document specifically designed for our clients, tabulated properly. Starts with our mandate. What's our mandate as Office of the DPP? And then goes and explains things like complaints. If you are dissatisfied with anything in the DPP's office, where can you go? Which number should you call? What email? Who is the person responsible? Where our service points are located in the country. So you can see the nearest one you have, how you can contact them. It allows contact by WhatsApp, by email. It also tells us if somebody comes to complain, after how many days should you respond to them? How should you respond to them? Should you call them? Should you send them a WhatsApp message? Should you send an email? And how you should get feedback. And so all these are contained in the document. Unfortunately, I don't have my copy here, so I cannot remember it. And so I will not give you some of those examples, but I hope the ones I have cited are sufficient. If you can reach up, if you're out there with the ELISON, please contact him. I will make sure I have either the soft copy or the hard copies delivered to you so that you can read and maybe
light on
perhaps
what
next
is
time
there and that you've given us. We'll definitely remind you as well about the copies and also check out on the sites that you have mentioned. And also you said we have some hard copies already, so we'll check them out. Thank you for sharing the highlight. Now, I'm just going to check out some of the questions that have been asked by the public, sir, and also our listeners. So, Anthony Natif is saying, what is interested in knowing what you intend to do about the prison population that is at more than 4 times capacity, with nearly half of those people being on pretrial remand, and why, with such abysmal prison congestion, does the DPP continue going for jail time as the first option? Why not allow for bail? So, Mr. Lino, you could advise, would you like me to read the 3 questions at once, or would you like me to just do one at a time?
I think let's do one at a time so that I can focus on each separately.
Okay.
And if I have addressed the next one, then you can perhaps take some more questions. Thank you, Anthony. On the day of my swearing in, I had a deep conversation with the Attorney General and the Deputy Chief Justice and the Principal Judge, who of course now my predecessor, who of course was a former DPP. And one thing we all jointly agreed to work on is to reduce prison congestion. So a reduction of prison congestion is top on my agenda. And how do I intend to do this? The first thing I want to do is to close the tap, the inlet tap. and the message I am going around the country delivering to all my prosecutors is this: don't let in anything that is not deserving to be in there. We are already heavily overworked, critically understaffed. We have a very big problem of backlog, and the workload we have and the backlog is already badly and terribly affecting the quality of service we are delivering, because we are unable to concentrate and pay attention and do anything with concentration and with dedication. And so the message I'm taking to them is this: close the taps. Close the taps. Only sanction cases deserving for trial and for court. So we are essentially, I am going to insist almost on a prioritization thing, that really simple assault, small theft, and so on. Yep, there will be a lot of public outcry. Yes, I understand, but sorry, please put up with us. You will have to resolve your problems. And my brothers in the police, my brother, my good friend, Mr. Tom Magambo, hardworking gentleman. Any case not well investigated, sorry, we will not take it to court. And so this is what I want to close the taps first, because the moment you close the taps, the inflow, and then you can deal with what is inside, at least more sustainably. So that is the first thing. We have the what we call the decision to charge guidelines, and this is what I am emphasizing to my prosecutors, to stick to those decision to charge guidelines, which set two tests. It is the evidentiary test, and the public interest test. So before you sanction any charge, it must pass the evidentiary test. That means the evidence must be credible, it must be admissible, it must be a lot of things which are in the guidelines. If that is passed, then the second thing is the public interest test. Okay, so there is evidence. Does it pass the public interest case? Is this really a case that should occupy a magistrate for 2 weeks, a prosecutor for 2 weeks, and maybe a court orderly, a defense counsel for another 2 weeks? Is this really a case of what
pass the public interest case? Is this really a case that should occupy a magistrate?
So this is what I am really emphasizing to them, and I am hoping in the coming days that this will be significantly noticed, that there is a reduction in the number of cases we sanction that are going to court. That one. But the second thing is this: all undeserving cases which are already in the system, I want them out. And so I have 2 weeks ago, I was making all the regional officers, we have 19 regional offices in the country, and I have already instructed them to do a review of all the cases in their possession. The biggest contributor, and Anthony, you're right, the biggest contributor to this prison population are remand prisoners, and most of these remand prisoners are remanded on capital offenses or for capital offenses, because those are the most difficult. And so I have asked all the regional officers to review all the capital offense case files in their possession and send all of them to me, those that are undeserving of being there, those whose evidence is a little wanting, those cases where the circumstances have changed because physically something which is wrong, either the parties have lost interest and things like this. Those ones should, so that we only concern ourselves with, because each of those cases is 1 or 2 people, maybe sometimes 5, sometimes 10 people in prison on remand, awaiting their trial. And so I am hoping that some of those initiatives will immediately and significantly contribute to reducing this very bad problem of prison congestion. And I am hoping that I will get support from all stakeholders, especially including the public, so that when my officers don't sanction your charge of assault because somebody has slapped you and you have a few bruises on your cheek, please please understand that that is probably a matter that can be resolved by the LC1 chairman. You can resolve it in the court and so on, but leave the prosecutors who are few. Please let them deal with the serious cases of murder, of defilement, of serious cyber crimes, of financial fraud, of corruption, cases that really really have create an impact on the country. And that way you allow us to reduce this prison congestion and deal with it. And I am sure it will make all of us more efficient. Okay, Joy, I think we can go to the next question.
Okay. Thank you, Mr. Lino. I hope, Anthony, you've been answered. There was laughter in the room when you mentioned people who have bruises, bringing it to court. And I remember there's a court session at the magistrates where there was a whole case about somebody who had stolen, I think, 2 eggs off somebody's tray. And that was also lined up as one of the files. So I think what you say is very true. Some of these things need to be thrown out in a bid to close the tap and let the chairman also have some work to do on the village. But I think they have so much, but probably that would be under their docket. Now, the other question is coming in from Philip Karuganga. He's saying the Constitution requires the DPP to be accountable to the people and to act in the public interest. And he needs you to explain the withdrawal of charges against Minister Lugolobi after court found he had a case to answer. Over to you, Mr. Lino.
Thank you so much, Joy, and thank you, Philip, for that elaborate question. I did not also participate in the handling of that case, so I do not have any facts on that case, and so I cannot explain to you and be accountable to you right now as to why that case was the way the prosecution was terminated. But I can only explain that decisions to terminate prosecutions in the office of the DPP are not taken lightly. I can assure you, for every charge which is withdrawn or where a prosecution is terminated after it has been commenced, there are a minimum of 3 or 4 levels of review of the case. Convince the director of public prosecution that this case is not worthy to remain in the system. I actually thought you'd be very happy that we are assisting with these very many backlog issues by dropping some of those cases, but of course we can understand that is one of the public interest cases. But I am sure my predecessor had a very good reason, and backed by elaborate legal opinions written by very senior, from the lowest to the most senior officers in the office of the DPP, advising the director of public prosecution to withdraw or to drop the case. And some of the circumstances really, and I can just cite some of them. I've been there. I know. Change of circumstance. A lot of the times, by the time you go to court, you believe in your case because of the evidence that you have in your possession from the police. You may have 1 or 2, and sometimes as the case develops, you start doubting your evidence. Through cross-examination, it opens a lot of holes in your digs, or punches a lot of holes in your evidence. Some of your strongest evidence, sometimes you see is just no longer holding. And you start recognizing some of the errors and mistakes that are made in investigations. They become more apparent, and you are sure that if this was done better, you could really do a better case. And so you really have to make a judgment call sometimes at a certain level and say, okay, should I persist with this prosecution and risk an outright acquittal, so that even if I get this, I correct this in future, I cannot prosecute it again? Or do I, because this is where it is, I don't have a lot of time to do this. I cannot ask for more time. I am already here. I am relying on another institution to conduct investigations for me, an institution that I don't control financially, even by supervision. Do I say, okay, let me retreat for now? Essentially saying, let me leave today so that let me live today, survive today, so that I can fight again tomorrow. And so those are some of the sometimes witnesses change their minds when you so many circumstances that contribute to the practice of the DPP's exercise of that power to terminate proceedings. But I think it is in good faith. It is all part of this thing we call justice. If you see that the case is not having a future, so why do you insist? Why do you insist on prosecuting it? And so, if the DPP is convinced, I think it is. If I get another opportunity and I am appraised of the facts of that particular case, certainly I will probably do it in private. But right now, I am not appraised of those facts, and I cannot. I cannot respond specifically to the reasons why that matter was terminated. Joy, thank you.
Thank you, Mr. Lino. I believe that was answered fully. And then we'll take, there's more questions coming in, but we'll just see according to time. There's this last bit I'm going to check in from the audience, and it's coming in from Lule Alexander. He says his concern to you, sir, is that whatever criminal backlog we have and the filling of prisons with committals is that most of the state attorneys do not do their work effectively. Many files end up being sanctioned with no evidence. I think you'd answered this, but since we are about public interest and gaining their trust, you may want to re-echo that, sir, and then we can continue. Over to you, Mr. Lino.
Alexander, thank you so much. I agree with you. I have just been in the office for a few days. I can tell you, I agree with you. I think some of the cases we take to court are really not deserving. And I can promise you, and let me give you a commitment that it is going to be one of my most top priorities to ensure that my prosecutors do their jobs better, and that we do not take to court cases to clog the already clogged system further. And so every case going forward that we take to court should really have gone through the necessary scrutiny. And I appeal to you, my colleagues in the members of the Bar Law Society, please educate our population. You have more access to them than us. Inform them. Sometimes the decisions we make, our officers make, are really independent and are made in good faith. If you reported your matter to police and the state attorney or the prosecutor tells you, I don't have enough evidence to take this matter to court, please let us trust them, because sometimes a lot of those issues are caused by pressure you, members of the public, apply to the prosecutors who just push your matter to court. So he's explaining to you it's a small matter. No. You just want to see the other person in court. And so it really, we can put it on the prosecutors. Yes, surely they probably should be a little stronger than that, but the pressure comes from the public, a lot of it, if not all of it. So leave them to do their jobs. If they have made a decision you don't agree with, the best thing is to follow it up and appeal it upwards to the supervisor to review it. My advice is, if two people have reviewed your decision and they are agreed, accept it and move on. Just know that that is the decision of the office of the DPP, but don't push people to take to court matters that are not going to advance, because that is really what is contributing to a lot of these people. And some of them, I agree, you look at them, you wonder why. Just last week, I had to call one of my officers. In fact, I wrote them, I said, I need to see this officer and this officer. Let them come and explain to me on what basis they made they arrived at this decision to charge? I want to understand, and I'm waiting for them. So when I get back to office, I am hoping they'll be there. And I have told my staff that is going to be the modus operandi going forward. If you send me a file to withdraw the charges, and I have the perusal of the charge, you had absolutely no evidence at the initial stage when you sanctioned it, I will want to call each officer, and I am going to write to them to come and explain to me why they sanctioned the charge in the first place. And some of those issues, of course, are issues of competency. People may not be they may not be competent enough, especially some of the recent staff we recruited. We did not have enough time to train them, to form them. Reason being, there's a lot of pressure out there for staffing, and so maybe the training we gave them in making prosecutorial decisions was not sufficient, and so they are making genuine mistakes, which is what we need to address. And then we can do mentorship, placement, and essentially try and assist them. But if it is absolutely unethical conduct, some of those cases will go to the Rewards and Sanctions Committee. So people will be getting a lot of letters, cautioning them, warning them, and a lot of things. And so we are really, I am really committed to stopping this problem, Mr. Alexander.
Thank you very much, Mr. Lino. The tabs are going to be closed now. For interest of time, we'll not be able to read all your questions, but we are going to recognize you. Thank you, Ashraf, Daniel Kamuntu, Seguya Enoch, Marvin Senyondo, Jesse Turi, Owinyu Dolo, Christine, Koleb, and everybody else that is listening in today. We appreciate your presence. Thank you very much. Now, Mr. Lino, before I hand the microphone back to Council ELISON, I'd just like to ask you a little bit about an issue on equity matters. Because I know that equity does matter to the people, and I think that's one of the things that you're aiming for in a bid to gain trust. So when it comes to the vulnerable communities, the groups, those groups often struggle in having access to justice. So how do you think the Office of the DPP is going to or can support them better? Over to you, Mr. Lino.
Joey, thank you so much. Equity, vulnerable groups, and access to justice. When you use those phrases in one sentence, you just see a lot of challenge. Joey, thank you so much. Equity, vulnerable groups, and access to justice. When you use those phrases in one sentence, you just see a lot of challenge, and that is one of the biggest challenges our justice system is facing for very many reasons. But I think the problem has been recognized. We were just observing 16 days of activism against violence against women and children, I think a few days ago, and the statistics that came out from some of the speeches there were really scary. For example, and I've seen this also in our reporting, that in all our criminal cases, at least 70% of the cases are gender and sexual based violence related cases, and affect vulnerable members of our society. And we're talking about girls, we're talking about women, we're talking about poor people, disabled people. And so we have a real problem of access to justice and equity for the vulnerable people. And so how do we support this? We have initiatives. First of all, we have created a whole gender and sexual-based violence and children department that specifically pays attention to justice needs of this vulnerable group of people,
and so they are aggressively working on these people on this in this particular category of people, making sure that their cases are resolved quickly. We have a few partners who have come to support us from the non-government organizations group. And so we are organizing right now. We are running special criminal sessions for SGBV cases and children cases, and so and you can, if you look at the returns, the statistics of the returns and the results from those cases, and compare to those we do in the ordinary criminal high court criminal sessions, there is a remarkable difference, because the results from SGBV cases are much better than the results from our ordinary criminal cases. These SGBV cases take shorter times, the convictions are more, the outturn of witnesses, the outturn of, in fact, the participation of everyone is more in the SGBV cases compared to the ordinary cases. These ones drag a little more. Sometimes they into other sessions, another session, another session. So that is one of the things we are doing. But also we are physically increasing our presence in the country. We now have 148 service points. That means ODPP offices across the country, which is, we are still miserably lacking behind the judiciary, but of course our resources are different. Significantly less than the ones of the judiciary. But we are very hopeful that we shall appeal and that we shall get the resources we need to catch up with them. And so 148 points, that means we are getting closer to the people in the villages, in the districts, in the countryside, to make sure that they can access. And now very soon we are going to go digital. We're going to have we are working very hard to put up a toll-free line that can be called by all our clients in case they need any support on clarification of our services and so on. So all these are initiatives that we are working on to ensure that there is equity, and that we pay special attention to vulnerable groups to ensure that they access justice equally like more able people.
Yeah, thank you. Maybe just one question from the comment section before we get to Mr. Elson. From Mr.
120 to prosecute civilian offences when untrained soldiers when soldiers untrained in due process dictate verdicts and potentially turning national security in trivial for silencing the dissent and silencing those of the DPP.
Thank you very much. I think you said the question is from Sequoia. Mr. Sequoia, thank you very much. I think we have responded to this question. I am assuming that is Alfred who is asking that. Thank you very much. I think you said the question is from Seguya. Mr. Seguya, thank you very much. I think we have responded to that question before. My predecessor has responded to similar questions before. Unfortunately, and I will say this, unfortunately, the office of the DPP does not have any mandate to peer into the affairs or workings of military tribunals, court martials. We are specifically prohibited by the Constitution from exercising our powers within or in matters affecting military tribunals. And so those are really completely out of our and we are a civilian authority, and so we really don't want to get into that business. However, I think if we effectively prosecute our civilian matters that are brought to us, legitimately brought to us by the police, we will be able to demonstrate our ability to handle these cases effectively, and by doing so, I think we will be defending our control over prosecution of private or civilians in the country, because we don't choose the cases that come to us. We don't force people. We bring this case unless we take cognizance of the case under Article 120 of the Constitution, and decide to refer the matter to the Inspector General of Police for investigation, and ask the Inspector General of Police after taking to investigate the matter and report to the Director of Public Prosecutions. There is no way we can, absolutely no mechanism in which we can reach out to the military to say,
Thank you.
no, since you have these people, you bring
If
this
you're just
matter to
joining
us.
welcome to Judicial
Our
Service
mandate does not
Conversations
extend to
inside
that
the
level.
mind of the DPP. We're having a full and frank conversation with the DPP. He's taking all questions and batting them away. And it's good to see the office of the DPP here with us on Judicial Service Conversations and answering these questions. I think there's so many questions coming through. I have one here from Mr. Nicholas Opio, more a suggestion than a question. He says there has to be a paradigm shift. A prosecutor's job is not primarily jailing people. The calling is much higher, the delivery of justice. Delivery of justice must include a refusal to indict or a mediated resolution of an accusation. A prosecutor should not measure their success or build their career on the number of convictions, but instead on how they deliver justice in its totality. The practice of charging folks and then claiming the case is still under investigation is poor practice. Pre-trial detention must not become a punishment in and of itself. How does someone sanction a case that is not fully investigated? And I think that's a question many members of the public have. This idea that the case is sanctioned, but inquiries are still ongoing. And then the inquiries remain ongoing, then the inquiries remain ongoing, and the man remains remanded or even on bail. I know a matter where, anyway, let me not go into that matter. It's a colleague of mine who is on the chat told me once about it. A man who got bail, but owing to the economic circumstances he was in, he couldn't afford to pay. So for the last 3 years, he has been paying his bail in installments. He's still on remand, and his inquiries are still ongoing. So I don't know. Do you have a comment on this? Inquiries are still ongoing that Nicholas is asking about.
Okay, I was about to say, be careful so that you don't cross into the sub judice Rubicon when you wanted to say about this case. I know. Anyway, Nicholas, again, my good friend. I've not seen you in quite a while, apart from seeing you on TV. Thank you so much for those observations and rather very strong words. I agree. I agree with you with everything you say, but I also want to make this comment that what you say strongly is the ideal situation, which works perfectly in an ideal society where everything works perfectly. You have sufficient resources, your police is well resourced, your judiciary is well resourced, your population is very well civilized, civic education, they know their rights, they understand all these things. It works. This really perfectly works in that kind of society. The question is have we already reached that level of society where we can stick to those ideas very strictly in the way you state them? I respectfully don't think so. I think we are on the way. We are making strides, but we are not yet there. We are still a little far. And so every once in a while, you have to make a compromise here. And again, it is a judgment call. Because I'll give you an example. Yeah, sure. We must conclude investigations. Yeah, investigations must be concluded before you can charge. You can do ABCD. But I'll just give you an example, a simple one. You have a common thief in town who probably is well known, and everyone knows the pickpocket, and pickpockets maybe $1,000, $2,000 from a tourist or somebody, and everybody has seen. They chased him. They have picked him, arrested him, and he's taken to the money is in CPS. Okay, so the matter is reported, and the money is there for 1 or 2 days, and our heavily underfunded and understaffed, and sometimes ill-trained investigating force, the police, is still running around putting a file together. They have done their best over 2 days. You have your 48 hours running. 2 days they have put up a file. Yeah, there is an exhibit there. You have the skeleton. If you look at it prima facie, you have, yes, I have a good case here. But okay, 48 hours are done. This man must go to court. And so what does it? File is sent to the DPP's office. The RSA can clearly see this tourist was in shock, taken to hospital, has not made a statement. But there's a witness here who says, oh, ABCD. This witness's contact is there, can be found. This is there. You just probably need to wait for another 1 or 2 weeks for all this to. So you have to make a judgment call. The file is before you. You say, the investigations are still not done, and so let me send this file back. Police, give this man police bond. Are you going to get him? You have the public who is down there waiting. Everybody saw the man. Do you think it is in public interest to, as a prosecutor, do you think? So you have to make a judgment call. Okay, do I make this decision? Because if this man, it is 48 hours. If you don't charge him, you have to release him. The man might disappear. No one knows where he lives. And so it's really, sometimes it is that complicated. That's why I said a lot of prosecutorial decisions are not in black and white, the way everybody thinks, where you just say, this one is black and it's there, and this one is white, it is down here. So some of those few cases slip through. I agree, but it is really a judgment call. Cases where the public is so outraged in the VA, everyone, they want to reach this guy, do you let the man go? So these are some of the considerations that make some of those inform some of those decisions. But I don't think it is just a practice that I agree we have a problem there, and that is what we want to stem, especially in the minor cases, which really don't have any significant public interest in them. And so I really want to put my effort there on those ones. But there may be 1 or 2 deserving cases, where, yes, you still have to take the case to court and initiate the prosecution before you have concluded all the investigations. And there is really no harm in that. The risk, of course, is that you may never conclude the investigations because you don't control the investigating agencies directly. You can write instructions and so on, but you have no control over what they bring back. That is the risk, but you have another power to terminate it if the matter is not concluded. So it is not a decision taken without a remedy. So the remedy is reserved, which is to terminate the prosecution if the investigations don't take so long. I think the challenge is that some of our officers don't draw those matters to the attention of the DPP early enough when they realize that this case is not going anywhere. But if we are using that effectively, I'm sure it will be a good way to address some of those instances. So, Nicholas, that is really some of the considerations that inform those decisions, and so we can't cast it in stone. Yes, that is the ideal situation, that all the evidence must really be collected first before you take the matter to court. But in 1 or 2 cases, you may find reason to say, let me start this prosecution and allow 1 or 2 days.
If you're just joining us, welcome to the Judicial Service Conversations. We have slightly more than 10 minutes. We'll be closing at exactly
in order to conclude it.
Hours. We're thanking you all for joining us and sending your many questions. I think one of the questions that that is coming through is technology and crime. Crime is rapidly evolving, and so these are, maybe I'll ask these two questions in one. Crime is rapidly evolving, and the emerging threats: cybercrime, digital fraud, technology-driven offenses. How is the DPP's office getting attuned to these technology-related offenses? And then also, technology itself is reshaping everything. Are there opportunities of modernizing the office of the prosecutor using digital tools, so that such that we don't have this problem? I have a friend. I was going to mention his name. He's a prosecutor here. I'm seeing him, but I think it will be worse than subjudice. So I'll not mention him, but he needs some digital assistance. So is there a plan to help improve the digital footprint of the office of the DPP? Office of the DPP.
Elison, again, thank you so much. You are right on point. Crime is rapidly evolving. We are moving into a digital world, and we understand it in the office of the DPP. I can tell you that right now, almost 50% or slightly more than 50% of the fraud cases we are handling involve some use of technology, one way or another. And so cyber crimes are on the rise. And so what have we done? We already have cases involving crimes involving cryptocurrency, virtual assets, and so on. We already have some of those cases already, and we are prosecuting them already. Some of them we already have in the system. That means we already have the minimal capacity to address those. But again, I think we need to train more people, especially in the investigations area. I think the resources we have in the investigating teams are still significantly few. And so we need to expand in that area. But internally within the office of the DPP, we have created an independent unit, provide assistance with those kinds of cases. It's called the Cyber Crimes Unit. Unfortunately, due to our staffing issues, we only have one officer there, but whose job is just to coordinate cases involving cyber crimes in the area, in the institution. But it's a point. But leveraging tech, using technology to improve the services. Again, I do not know how I did not mention this, but this is another priority area for me.
Products that eventually just turn into white elephants. We have a case management system in the office of the DPP, which has been running for the last 10 years, called Procamis. The initial design really was that it's designed to assist us to manage our cases, assist us with case management in the office of the DPP. But we are facing quite a number of challenges with it, with the uptake of the visibility and usability of the system. I think it's been a challenge. Its uptake has been a little problematic, and so we recently advertised for its upgrade and update. But I will check. It looks like the bidding process is underway. But we are very intent on harnessing the power of technology to make our prosecution.
Advertise for its upgrade and update. But I will check. It looks like the bidding process is underway. but we are very intent on harnessing the power of technology to make our prosecution, to reshape the future of prosecution in the office of the DPP, so that tomorrow we're able to serve you electronically, we're able to notify you about your complaints electronically, we're able to prosecute our cases purely using electronic records without having these physical case files. And we're thinking that way we're able to respond to your complaints promptly, because we're going to cut out this business of you having to carry, our officers having to carry physical police files from Amudat, from Nakapedipirit all the way to Kampala just to get a withdrawal from the DPP, or to get the DPP to reduce it. And so we have a very good in our strategic plan. We have a very good technology strategy which we're going to develop, and it is one of the key things I am looking forward to achieve during my time as office of the DPP. And I am hoping in the next few years I can come here and talk about it.
I think you can all hear.
And see and elaborate how far we have gone in adopting that system, improving the one we already have.
Who can catch up? But we have about 7 minutes to close, and we have here with us one of the prosecutors, Timothy Amerit. The A is silent, I think, so it's Timothy Merit. So, Timothy, maybe just in 2 minutes, if you could just say something, yeah.
Thank you so much, Elson, and thank you so much, Mr. DPP, for the guidance and comments that you have shared throughout this call. As prosecutors, we are privileged to hear your guidance, which will inform, the practice, the prosecutorial practice for the coming years going forward. And this is refreshing, because as we start the new year very soon, the prosecutors have a philosophy, they have a mindset, they have a theory of the type of prosecutorial practice that we should be engaging in. And we hope that going forward, there will be a sense of prosecutorial neutrality by prosecutors disengaging from the cases that they handle and handling cases solely based on the evidence and the law as is seen in the cases that we handle. And as we are aware, the office of the DPP is created by the Constitution of the Republic of Uganda, and no other legal regime therein. So we hope to exercise constitutionalism, what we call prosecutorial constitutionalism, in the exercise of our duty, bearing in mind the issue of objectivity, impartiality, and accountability. Hopefully when we do that, we are able to erode instances of prosecutorial overreach and abuse. My Lord, the DPP, we are used to calling the DPP my Lord. Yes, the DPP began by considering the principles that inform the exercise of the prosecutorial mandate. That is the principle of public interest, the principle of the interest of the administration of justice, then the need to prevent abuse of legal process. And Nicholas Opio raised an issue of investigation. We may need, together with the GSC conversation group led by Mr. KARUGANGA ELISON here, we may need to think about to focus on what areas of constitutional amendment we need to put into place in order to foster the exercise of the prosecutorial mandate. Right now, for example, Mauritius is making is in the regime of changing its constitution, And one of the proposals they have is, among the principles that they want to add is the principle of evidential sufficiency. That before you take a case to court, before you make a decision to charge, the evidence must be sufficient. So in addition to the three principles, it would be good to have this also incorporated within the Constitution. I know there is a call for a legal framework that operationalizes Article 120 of the Constitution. But if Article 120 in itself is not sufficient or is lacking in principle, then can we first build a superstructure on that article, make it stronger, firmer, so that it creates a prosecutorial platform where all of us Ugandans shall be proud and shall want to practice in. So with this ELISON and team, you would work together with the DPP, who is forward-minded, who is looking towards change, who is looking towards improving the practice of prosecutory exercise in this country, so that we have a more comprehensive administration of criminal justice, which you in the defense and any other vulnerable person out there would be proud of and know, yes, we have a DPP that is functioning, but you know that functioning starts with the supreme law of the land. Thank you so much, the DPP, and we look forward to working together with you and upholding your hands as we administer criminal justice in this nation. Thank you so much.
So thank you so much, Timothy. I see we have a minute, but just yeah. Okay, I think we have a minute. So now I think there's a question which we have gotten.
He's just commenting.
Thank you very much, Mr. Lino, for coming to this space and being here with us. After service conversations, my question, yes, you have tried to answer it, but then there is always at times the political interference when it comes to the aspect of prosecutions. So as the new DPP, what is your office going to do to answer that question of political interference in the aspect of the political interference in the prosecutorial mandate and getting the public trust? My name is Kevin Lino Odoki. Public trust.
Is that Alfred?
Lino Odoki.
Okay, all right. Thank you so much. Political interference. I think the challenge is really just interference with the exercise of the prosecutorial discretion. It is not just politicians alone. It is everyone, all of you. If I showed you the number of people who are calling me and telling me to sanction this charge or to drop that case and so on and so on, not even 10% of them are politicians. I don't even think 5% of them are politicians. In fact, it is the same thing. Whether it is, in my view, whether it is you're trying to use bribery, whether it's corruption you're trying to use to influence the exercise of prosecutorial discretion, whether it is just by ordinary undue influence, talking to somebody, exploiting your relationships with a state attorney or a prosecutor in order to influence, whether it's a politician picking a call and calling a state attorney and saying ABCD. The underlying problem, in my view, is undue interference with exercise of the prosecutorial discretion. And you always cover it. Everybody covers it as if they're just trying to advocate for their own interests, to make sure that their interests are taken care of. But how do you deal with it? Listen to it. It is our job to listen to members of the public. And so I am not going to refuse to answer a call from ELISON because he wrote a complaint and is following up on a case. Yes, absolutely. My only request is, how do you deal with it? Make your decision after taking into consideration and account every relevant matter that is relevant to you making your decision. Some of them are relevant considerations in making your decision. If they fall under the public interest consideration, after you have passed the evidentiary test, and then you can consider the other public interest considerations. So your job really is to consider, I think, as a prosecutor, is really just to weigh the interest that is being driven by the politician, the interest that is being driven by this person. Does it fall within what is permissible public interest consideration to influence this decision or not? And ultimately, a prosecutor must be responsible for the decision he or she takes. I think it is escapist, and I think it is utterly wrong for a prosecutor or the DPP to say, oh, I just took this decision because this politician was putting me on pressure, or so and so. No, that is totally unacceptable. You must own the decision because you took the decision yourself. There is no politician who came to hold your hand to tell you what to write. No. You're protected by the Constitution. Maybe we can improve the constitutional protection a little bit, but surely the DPP, his officers must be responsible for the decisions they take. If they decide to take into consideration the interests of politicians, that is purely on them. That is purely on the DPP. It is not. And so it's up to the DPP to discern and say what issues am I taking into account or consideration in making this decision, and what issues I am not going to take into account in making this decision or to change my decision. And so, really, in terms of what I am going to do, there is nothing you can do except just be objective and explain to people why you cannot. I have had a few people call me, and I have told them, sorry, but we have evidence on this man. We have overwhelming evidence on this man, and the man has to go to court. Sorry, we don't have evidence on this person. There's nothing we can do for you, Honorable Minister, Honorable so and so, Honorable. So this is it's really about being open. And those of you who work with me in my life over the years as a prosecutor, you know that is what I do. And I will tell you that this is possible and this is not possible for ABCD reasons. And this is a part of the prosecutorial accountability I will be looking to exhibit in the office, but I will also be looking out for it to see it in all my officers to make sure that we can stand our ground and explain our positions and take responsibility for the decisions that we take.
Politicians, and he has gone as far as actually giving me a few names of people who he says are notorious about making calls to prosecute others, but I will not read those names for fear of being sued for defamation. I think we're winding up. If you're just joining us, ladies and gentlemen, you're late. We are winding up this conversation. We're a few minutes late. I think there are some questions. You'll forgive me, I'm not able to ask them. I've just seen a question from Mr. Seguya. He will forgive me, I'll not be able to ask it. There's a question about human rights. Maybe I'll close with that one. Just two questions here. One is, human rights are now a central part of conversations regarding justice in this country. How do you balance a strong prosecution while protecting the rights of suspects, victims, and the wider public? As you answer that question, Lino, if you could also give us your closing remarks. And then how it works here is that I give the final closing remarks. We don't follow protocol.
Edison, thank you so much. Of course,
And then how it works,
between
I give the final
human
closing.
rights and criminal
We don't
Edison, thank you so much. Of course, the delicate balancing act between human rights and criminal prosecutions. The debate has always been there because, intrinsically, the criminal justice process is an infringement on human rights. The criminal justice process is one of the constitutional processes that permit the state to interfere with the human rights of its subjects, of its citizens, legally by law. And so you get arrested, your freedoms get restricted, and for the even just on suspicion that you committed a crime, not really because you've been convicted or anything. And so I think first thing we need to recognize is that the criminal justice process itself it erodes on human rights, and so the question it will be, how do you ensure that erosion or that interference does not go beyond what is necessary or what is justifiable in the circumstances. I think the approach really for the prosecutor and for the office of the DPP is really to ensure that human rights are observed during the process of investigation and the prosecution, and that cases where there are distinct instances of and this evidence of very gross and human rights abuses, essentially to condemn them and to refuse to accept them, because human rights are our rights, for everybody's rights, and so we just have to speak up and say this is unacceptable. This we cannot accept. This we cannot do. This in matters of bail, in matters of prosecution, in matters of charging, in matters of ABCD. And so I think that is how the office of the DPP can really ensure that human rights are observed. But also these issues sometimes need to be triable, because the office of the DPP usually, and in most cases, just deals with paper. It doesn't deal with the human beings. Many times, the first time you see an accused person or somebody who is in court, when they are produced in court, and you are not properly instructed at that time as to what happened to this person and so on, because you take your instructions primarily from the investigating machinery. And so if your instructions is that no, usually there'll be a good explanation why this person is here. And so in many cases, you find yourself in a little bit of a dilemma that you cannot own up, but you cannot also just keep quiet. And so it's a little bit of a dilemma for the. I wish we have started a prosecution guided investigations approach to some of our serious cases, but of course there is also a challenge in that, because we have two bodies, prosecution and investigating machinery are separated, and so you don't want to cross from being a prosecutor to being an investigator. So we don't go into those police cells and interview cells where they're interviewing and so on. We allow that so that you can maintain your neutrality and independence as a prosecutor, but also stop yourself from becoming a witness in the matter. In many other countries, of course, that Rubicon is not very clear. So prosecutors go to the crime scene, they sit in the interviews, they can suggest the questions to be put across, and they can view certain things early enough for them to make certain decisions. Here is a little bit different, but I think that is. But also, we already have a lot of safeguards. We have the Human Rights Enforcement Act, which some of those sections I really don't agree with. But those are tools that assist, also check on the DPP's performance of his functions and ensure that the human rights of accused persons are respected. All right, so I think that's what I would say. Ellison, in my concluding remarks, I want to thank everyone, and I want to thank you, Mr. Ellison, and your team for the important work you're doing on these JSC conversations. I don't know why you call it the JSC conversations. I think because you started this around the time when I think you were running. I think you're still in the running for election to represent the Law Society in the Judicial Service Commission. But I think it is one of those very insightful and very, very meaningful innovations that you have come up with. I always tune into it and I listen to the discussions, and they're very, very informing and very, very enriching. Your choice of guests has always been top notch, and I hope your listeners this evening and those who have logged in have benefited from these discussions. These are just sharing ideas we have in our head. And I am hoping and looking forward to working with all of you, the office. So please give us feedback. Please support us. Tell us areas where we need to make improvement, areas where you think, and commend us for areas where you think we are doing well. But we are trying our very best to give you the prosecution service that you desire. And I am hoping that Edison, that you can call me in the next another 2, 3, 4 years to come here so that I can tell you how much ground we have covered since my appointment and what good progress we have made. Otherwise, thank you so much, and I wish all of you a very good night.
Thank you so much. It is also, you are right. The reason why this is called the Judicial Service Conversations is the JSC Conversations is because really we are interested in the service of justice, and our argument has always been that the courtroom must be transformed into a service and not just a building, and that has always been our position. I will allow one speaker for 1 minute, and the reason why is because you will see there's a colleague of mine who is on, who once received advice from the person I'm going to allow, and I saw him tweeting in complaint about that advice. I'm sure that's not the sort of advice that will come, but I will allow Honorable Eli KARUGANGA to say a word. Once received advice from the person I'm going to allow, and I saw him tweeting. I'm sure that's not the advice that will come.
I'm kind of lost for words. First, the topic inside the mind. Oh, I didn't expect to be allowed. Thank you. I'm kind of lost for words. First, the topic inside the mind of the new DPP, the future of justice. There is also the law, but I emphasize justice. I've listened to the mind of the DPP, and I'm extremely overjoyed. You know, I have been in this business of law for the last 50 years when I got my practicing certificate. And one of my classmates was DPP. Don't need to mention his name. But I want to tell you, like an elder now, our brand new DPP, a good leader of any organization can build a great institution because he inspires trust. What we have done today was pure honesty, transparency. You have no fear of speaking your mind. There was a big degree of fairness, and you exhibited the qualities of a true leader. I know you will adjust to reality. I know that any leader, like you have been saying, will have ethics, justice uppermost in your mind when you sleep, when you wake up, and you will know that there is accountability at the end of the day in whatever you do. And when you ask ELISON to call you in 4 years and you will account what you have done, it shows you already have a determined, great vision. And you know you are going to develop your people, share those values. You are head of a very sensitive organization. I happen to have been very lucky to be one of the framers of our 1995 Constitution. And we, in that discussion, being a lawyer, you would expect I participated very actively in the clauses that give you the power of independence to be able to govern and to lead an organization. We were very, very mindful of the sensitivity of your office and the sensitivity and risk your staff are subjected to. You have already witnessed crimes against your staff. People who have been murdered because they were doing their job and they have left their children. It is a very, very sensitive job, and yes, you need our prayers. I pray for you. I am so impressed by this interview. And I think we don't have to wait for 4 years. I think we can wait for a year. Let me leave you with something to think about as you drive from Jinja or Busoga, wherever you are, back to Kampala. You know, the office you occupy is not unique. Every country has a top prosecutor, has a DPP. But not every country has the same laws as we have in Uganda. In the United States, they vote for their prosecutors. In Japan, they don't. But you don't come to court unless you are 100% sure you are going to win. So for them, DPP gets 99% convictions. In France, very different. In Britain, they don't vote for prosecutors, so like Uganda. So what I'm asking you, as you drive back, can you scan the world? You have a chance to revolutionize that office from its current structures. You can become a disruptor, and you will get support from young people who are coming to parliament, because the country is transforming. You might be a transformational leader. From the inside the mind of the DPP I've listened to, I think you have generated confidence. I wish all the members of the Law Society had this conversation tonight. Because once you win the hearts of the members of your profession, you have done a lot. For me, I'm completely won over. You only have my prayers. I'm speaking like an elder of our society, and I know what I'm talking about. I have listened, and I thank you, ELISON, for giving me an opportunity to pass these compliments to our leader. And I want to clap for you. Thank you so much for tonight. Drive safely on your way back.
Good night.
We need you.
And very, very kind words and
What
encouraging
mean
words.
that this time you didn't say declare the conflict of interest, but I can say why. My senior, our elder, thank you so much for those very kind and very, very kind words and encouraging words of advice. I always tell people this country belongs to us, and the spirit of the country, the soul of the country rests in our elders who pass it down to us. And so those of us, me, ELISON, it is our duty to sit down and listen to advice. And so thank you so much, my senior. Thank you so much. You are more of a father, as you said, than a colleague now. And really, you have spoken from your heart. I am really, really humbled and honored by your comments. And I was taking notes as you spoke, and I will be looking forward to your support and your guidance as I embark on this journey, which is ELISON called it an inevitable, a thankless job. But I think it is really just a calling and an obligation. And so I pledge to do my really best to make sure that everyone in this country really gets justice. I think that will be my happiness. So, ELISON, thank you so much, and thank you so much, my senior.
Thank you so much for
I
everybody who
wish
has
all
joined
of
us.
you a good night. ELISON, please don't call me.
I think if there's
again
one
now.
message we can carry forward from
The
this
time I
conversation
gave to other
is
people,
future
to other things
justice
has already
is
passed.
not going to be shaped by silence or distance. It is going to be shaped by conversations like this, conversations with the people at the heart and center of the administration of justice in this country. And I think everybody who has joined, I cannot add more than what has been said. The comments that have been made, I agree with. And I think it has been a good conversation. It has been a wonderful start to the conversation. And I think this is what public life needs. A quality, no holds barred conversation. A conversation that lifts the service of justice higher. A conversation about change. A conversation about reform. A conversation about improvement. A conversation about realizing that the member of the public is the master and the consumer of the services of justice. A conversation that has been had today with none other than the Director of Public Prosecutions. I think all of us at the Judicial Service Conversations are extremely happy with this conversation. We have overshot our time by 26 minutes. We had promised the DPP and ourselves that we shall close at exactly 9 o'clock. Thankfully, making promises is not yet an offense for which a file can be sanctioned. And also the DPP has made it clear that some of these civil matters, he's not going to be sanctioning them. So when you promise him that you stop at 9 and you continue till 9:30, at least also he has realized his new decision to declog the system. These sort of conversations but we are grateful to everyone who has joined us from wherever you've joined us from. There are two things that we always do when we are winding up. The DPP listens, but just in case he doesn't, I see one of the people who keeps injuncting us, Mr. Byamazima. I think he likes going to seek injunctions because he's enjoying the conversations. But whenever we're winding up these conversations, there's a song which we recommend to members of the Law Society, and the song which really it came by public demand, and it's really about our election. It's only part of the conversation that really focuses on the election, and so this song is, where else will you find conversations like this? Who else will bring them to you except us at the Judicial Service Conversation? So when finally, nowadays the way they injunct us, we are not sure if we should be campaigning to guys who are now filling out job forms at HSC to apply for LLB. But whoever you are now, but members of the Law Society, present and mainly future, when that moment comes, the question will simply be the one we're about to ask you. But from us at Judicial Service Conversation, to you, good morning, good afternoon, good evening, and good night. And the song and the question is... Oli mujawo musajja singa, oli mujawo